She walks it loud like a thunderstorm, debunking myths with style and form. True crime, conspiracies, her game. Melissa Jade, remember her name. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Microphone fierce like a roaring lion, unveiling secrets people been hiding. True crime queen of the digital scene, Melissa's got you hooked on her screen. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. From murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. 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 She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame.
Hi guys, happy Sunday. Yes, we're doing an early one tonight because we're going to be over on Alex Erickson's to start George Anthony's testimony for the case against Casey Anthony. And so I'm like, I want to still come on. I want to get through some of this Idaho documents. And so yeah, we're going to do a little bit early one, a little bit of a shorter one. But we're still here, and I'm happy. Hi, Shay.
Hey, how are ya?
I'm good. How are you?
I'm good. Sorry, it took me a second.
Well, I'm sorry for anybody who's having a little bit of a rough day. We are here. I'm happy that you guys are happy to be here. And Brandy, I don't know if you knew that you won a Patreon a couple of nights ago. So if you didn't know that, you got a Patreon from DB and Bentley, so you just got to shoot me an email and I will send that to you. We're doing Patreon tomorrow night after Members Only Monday. So welcome. We're going to jump right into it because I know we don't have super long before Allie's. And so I want to get through as much as we could get through, and I'm ready for it. So let me pull up our missing child for tonight's stream. This is Nicole Marie Scott. She has been missing since July 19, 2024 out of Columbus, Ohio. She is 12 years old. We have an associated child, Taya Lynn. They were both seen on July 19, 2024. Here is Taya Lynn, who she looks so mature for 14 years old. But again, female from Columbus, Ohio. So if you or anyone you know has information on their whereabouts, please contact the Columbus Police Department at 1-614-645-4545. Okay.
She's cute. I like her pink and her braids.
I know. Hi, Jenny. Yeah, you did, Brandy. I figured you may not have realized. So yeah, just shoot me an email and I'll send you the link, hon. Hi, Gidget. Hi, Mirabelle. We're on early tonight. Yes, Kohberger and Casey. Just prepare because Casey, you know, like with George Anthony coming up, we know it's gonna be he's the first witness, Shay, and it's gonna be heavy after opening statements with the allegations they put forth. So
I know. Y'all have been doing so good on your coverage. I've been enjoying it. I've just been in the bushes.
thanks. Hi, Carolyn Coops. Yeah, Shay was just telling me about she had like what was it, a tornado? Like what was it?
Yeah, we had a tornado sirens going off. It's calmed down, but like I'm in Northeast Texas, but what I heard, Melissa, is the Tornado Alley, the Midwest outbreak is happening really bad today. So they're having a rough time.
Oh wow.
And we were just at the tail end of it, you know, it wasn't as bad.
Well, prayers that everyone is okay and stays safe. Yeah, please be safe, Cicely.
It went from it's like 90 degrees today, and then we got a cold front coming in. It's like just drunk Texas weather, just back and forth.
Yeah, drunk Texas weather.
But I am so looking forward to this because I think the internet is popping off about what's going on with the Kohberger and Idaho 4 case.
And so I'm like, well, probably we could do maybe another, not tomorrow. Tomorrow's only Monday, but maybe Tuesday, because I know we want to catch up on these. And so I'm like, even if it's a quick one, I got to come on and we got to get through some of them. And so we have more new ones. I kind of want to open the text messages, and then I know we should go for the AT&T timing advance records, right?
Yeah. So the affidavit ones, those those are the longer ones. So everything else is pretty short.
So these are short. So we'll just start off. Hello, welcome, Mallory. Please hit the thumbs up if you guys haven't. Thank you all so much for being here for this early Sunday live. And let's get right into it. So this is the notice of filing declaration in support of the defendant's objection to the state's motion in limine regarding the text messages and testimony. So this is very short and sweet. And guys, we are preparing for the hearing. The hearing is a little over a week away. And so all of these motion in limines will come into play. And so I'm very excited to see what Judge Hippler does. So this one just says, comes now, Bryan C. Kohberger, by and through his attorney, hereby files the accompanying declaration of Josiah Roloff in support of their objection to the state's motion in limine regarding the text messages. Okay, that's it.
Right. So they'll just basically argue these motions in front of the court since they can't come to an agreement, and then Judge Hippler will make a decision.
Objection to text and testimony. Yeah, so a lot of this is going to what you're going to see, guys, and the limines are specifically basically like in layman's terms, you know, what we are going to fight. You know, hey, I want this thrown out. No, you know, state says, you know, like this is why it should stay in. Defense says this is why I want it out. And they're trying to figure out what is going to actually be as evidence presented come trial. And if they can't come to agreements, it'll, you know, be Judge Hippler who gets to decide what stays in, what stays out, and they'll make their arguments in front of him.
And I think what I'm really interested in, Melissa, is seeing how what we went over in like our first part of this series was the Franks hearing order that came from Judge Hippler. And so like how he will view the law and what will come in, because we're seeing a lot of the same complaints that were in the Franks hearing motions on these motions in limine.
Right. I don't know. I'm very curious to see. And listen, some of the arguments I feel like are silly, even though I understand that that's what needs to happen. But there are other arguments where I'm like, all right, that's a pretty good argument. You know, like I could see both sides there, or one side more than the other. And I'm curious. I think Judge Hippler is fair. I just think he's to the point. You know, like, hey, we're gonna keep this on track. He does not want this child to be pushed out, and so he doesn't want to do the whole back and forth. And I love that a lot of times we won't hear the judge too much, you know, like you'll really hear the state and defense kind of go back and forth with minimal input from the judge. With Judge Hippler, and I really noticed this last court hearing, is wow, he kind of comes in when the state doesn't need to come in, or when the defense doesn't need to come in, and speaks kind of like, hey, like I'm cutting ahead, and let me ask my clarifying questions, and let me kind of see where are you even going with this, because I don't need to hear the opposing side if I don't even think that we should get to that point.
Hmm. Yeah, and remember that like small, like little 2 to 3 minute clip I sent you that we found of how Boise was preparing, or Ada County was preparing for this hearing, and they were talking about at the end about Judge Hippler is like very well respected amongst the judges in that court system. He's looked at as a leader, and I think that says a lot.
Wow. Yeah. I don't know. I'm excited. I think this is going to be a big court hearing, though, to figure out, all right, what's going to come in, what's going to come out.
Oh yeah, this is where it's even gotten like the most fiery, and some of the other cases like we followed from Delphi,
Yeah. I'm excited. But that's why I'm like, we got to make movement on this because I want to kind of be as much up to current
Right.
as we can.
So we've got over the timing advance reports with everybody, and then our last live we went over the self-authentication records that included the AT&T warrants. So now we got the defense coming back on an AT&T timing advance record.
And just to remind you guys, with the AT&T timing advanced records, that is specifically the phone telling you like where exactly you were and those movements. And the issue is that they're saying, hey, you were able to get these specific records for other people, but not for Bryan Kohberger. And the thing is that at that time, AT&T timing records were only saved for 7 days. You have to remember, Bryan Kohberger was not even identified till the end of December and then arrested. I would think it was December 19th, and then December 29th was the arrest. And so they did not have the timing advance records for him saved, versus the others where they knew right off the bat, right? Victims, they knew right off the bat we needed those. But okay.
And there's differences in the timing records versus what the phone would say. Like, so if they were able to get like Bryan's device and try to see if the phone's been turned off, it may have been too long for from his arrest to the incident to see if any of that has been reset. I don't know. So that'll be interesting, because I think sometimes people were putting the AT&T timing advance records in as like, it would also tell you if the phone was on or off. No, this is just if it's connecting to the network. Phones can go in airplane mode. They can be shut off. We don't know.
Yes. Correct.
The status of what his phone was in at that time.
All we know is that it disconnected from the network, which could mean a couple of different things.
Right. And I think that's just such a huge point, because I see a lot of people getting confused by that.
They say that from early on, even in the PCA, like it could mean XYZ.
Right. But still such a hot topic, because, it's oh Lord, this is a big one.
I know.
This is going to be a fight. This one's going to be a big fight, the AT&T timing advance records.
And we're going to, once we get through, like going through all of these, we're going to be having a live where we talk about the hot topics going on and the arguments and where people kind of are going with theories. And we're going to do our debunking when we're able to do our debunking. And then we're going to be open-minded to things that we can't debunk, because that's how you kind of get through to the bottom of it. Is, hey, I actually can't debunk this. And so I think there's some more maybe validity into it, or you're open to it. But the things that can be debunked, we should debunk it, because what's the point of going around about something possibly like a possible theory or something someone's putting over if we know it can't be true. It could be debunked.
Right. I think we're at the point where like because we are heading into trial, like, we followed it from the beginning. We knew that there were a lot of people that were pointed out as persons of interest per se in the public's eyes, right? Not what law enforcement said. And that speculation just has continued and now stirred up even more. So, everyone, just advise you, be careful. Like, don't dig in too hard to these people and these families or dox them. Like, enough's enough.
So Hartlett's saying Bryan's phone was off according to the state's reply to the defendant's objection to state's motion in limine regarding the alibi filed the 21st. Okay, I'm going to go back in, Harlot, and I'm going to check that. And this is what I was just saying to Shay, with the overwhelming amount of documents that we have. it bothers me. It doesn't bother me to get the information versus to kind of be blasting through these. There's so much little details that I'm nervous I'm overlooking because we have so much to go through. And so I know we need to go back and kind of like pick it apart and go through it again and see, hey, what may I have missed?
Right. And I do recall it saying that it was turned off as well.
Okay. All right. Well, this is the notice of the filing affidavit in support of Kohberger's objection to the state's motion in limine regarding the AT&T timing advance records. And so it says this affidavit is filed pursuant to the March 18, 2025 courts denying witness testimony at the April 9, 2025 hearing subject to the court hearing remote testimony. And this is the hearing that, like I said, a little over a week away. And this is Ann Taylor. And right here we have an affidavit of Cy Ray. Cy Ray is the defense expert witness regarding Kohberger's phone. Okay, so remember they say that his alibi will be able to be proven cross-examining and questioning the witnesses and expert witnesses. And I think that Cy Ray also is going to come into, I think their entire argument is going to come in with Cy Ray being the main expert, aside from the expert testimony about his diagnoses, which really is not about alibi at all.
Right. And I mean, I go as far to say if like, say Anne and the defense team along with Cy Ray are going to rely on like photos that were on Bryan's phone, well, that metadata is super important. And I think they should have forensics look into that, you know, because at this point, we don't have him on any network. So where was he?
Right. Exactly. So this is just his normal, I'm over the 18, been working as a field of call detail record analysis for over 25 years, certified police officer in Arizona, 1996. I worked with my first AT&T records in 1997. I spent nearly 20 years in law enforcement in the primary role of a detective. I have worked hundreds of death investigations and consulted on over 1,000 homicide cases in my career. Extensive experience utilizing call detail records and exploiting cellular networks for investigative purposes. 2014, retired from law enforcement and started a business called ZX, created software for law enforcement to map and analyze call detail records. As part of that business, they maintained software that supported every known call detail record provided to law enforcement in the U.S. To date, the system has analyzed over 3 billion calls from call detail records provided by cellular phone companies in the U.S. 2021, LexisNexis purchased ZX and to date is still using and selling the software they created. Worked directly with engineers at the cellular phone companies for over 2 decades and intimately familiar with the type of data they maintain in the normal course of business and provide to law enforcement. So he has also instructed classes on utilizing cellular records in criminal investigations for nearly 20 years. Let me see. He has been a geolocation cellular investigation subject matter expert course in this field. Okay. He has established well-known and used best practices within the discipline of a call detail record analysis. Over 1,000 law enforcement agencies have attended Cy Ray's courses on the subject matter of cellular record analysis. Regularly consulted by prosecution on investigations around the world. As a recognized subject matter expert in this field, I have testified on that matter more than 100 times throughout the U.S., in both federal and state courts. So apart from this case, which this is interesting though, apart from this case, all my testimony in this field had been on behalf of prosecution. It is only in rare cases and circumstances I have ever considered working on the side of the defense. I remember that was massive when Cy Ray came on. It says, I have worked extensively with timing advanced data from cellular phone network providers over the past 15 years. I have testified to the use of timing advanced data numerous times. I have created and taught hundreds of classes on this subject matter to law enforcement. I am extremely familiar with the type of timing advance records available from U.S. cellular providers, their retention periods, and the legal process to obtain those records. You want to go?
Timing advance records are maintained by cellular network providers that provide a time measurement. This time measurement refers to the amount of time it takes a radio signal to travel from a cell site. Hey, Woofy. Travel to a cell site to a mobile device and back to the cell site. So given this signal travels at a known constant speed of light, it is possible to use the measurement to determine the distance the mobile device is from a known cell site. Which we did say this in the Leilani Simon trial. Remember whenever they did that like diagram and the crossing, Melissa, over the planes? That's exactly what that cast report is. And Murdaugh had a really good one. We said Daybell Vallow. I've been looking a lot into it. Okay, sorry. When multiple cell sites record timing advance data in short periods of time, it is possible to use trilateration to determine the location of a mobile device. The use of timing advance data in this manner is one of the most accurate ways for law enforcement to locate a mobile device. Given these records are available in a historical context, it is possible to conduct an analysis of timing advance data to pinpoint historical locations of a mobile device at a given date and time. It is also possible to determine routes of travel, stagnation, and when a mobile device is powered on and off. Okay, interesting. As a result of its accuracy, requesting time advance data has become a standard practice for all law enforcement in the United States and is regularly requested through legal process relating to a criminal investigation. AT&T timing advance. In August of 2021, I was approached by an FBI special agent to assist in analyzing a type of record set identified as AT&T timing advance report, and it was the first time I was made aware of this type of data from AT&T. Upon request, I can provide the date, time, location, and FBI agent I assisted with the record set. As of year 2021, AT&T had not officially released a timing advance report to law enforcement. Therefore, the ZX software program did not yet support AT&T timing advance records. As a result of this interaction with the FBI, I obtained a copy of the timing advance report from the special agent and forwarded it to our software engineers to write code within the ZX system to support future uploads of this timing advance report format. The next day, I was informed by the special agent the AT&T timing advance report was not supposed to be released or viewed outside of the FBI, and that individual requested I return the report and not have any software developed to support the data they'd shown me. I did return the report. However, due to the interaction explained here, there is a paper trail documenting the facts of this interaction. I have firsthand knowledge that AT&T was providing the FBI with timing advance reports prior to August of 2021. AT&T legal demands. During my careers working with call detail records from every cellular provider in the United States, I have been involved with thousands of cases in which call detail records are obtained from these companies, leading the way in the establishment of best practices within this field of investigation. I wrote and provided custom search warrants for every provider and distributed them to thousands of law enforcement officers in the United States, assisting them in the legal process of obtaining the vast and ever-growing amount of data sets offered by cellular providers. I have worked at the AT&T Global Legal Demand Center, also known as GLDC, for over 15 years. I have firsthand knowledge that the AT&T GLDC is one way, not the only way for law enforcement to obtain call detail records from AT&T. I have firsthand knowledge that there's another way to obtain call detail records from AT&T without going through GLDC. Over the course of many years, AT&T has had several different programs in partnership with law enforcement, primarily the FBI, that allowed for all call detail records to be disseminated to the FBI without going through the standard GLDC process. Oh, sorry, I was reading her thing. The first AT&T timing report I was presented and had a chance to review and became familiar with in August of 2021 was obtained from AT&T through one of these programs, not through GLDC. I have been involved in numerous investigations where AT&T call detail records were obtained through these AT&T programs outside of GLDC. I have firsthand knowledge and experience in working with individuals at AT&T associated with these other programs. One such individual is Boyd Jackson. Mr. Jackson's a program director at AT&T who manages many of the programs I'm referencing. Mr. Jackson is the primary contact for the FBI when requesting records outside of the standard GLDC process. GLDC disseminating timing advance reports. The state is correct in their claim that AT&T GLDC did not provide law enforcement with AT&T timing advance reports until May of 2023. As a matter of fact, in May of 2023, the working group known as GLDC had only begun their storage of timing advance records. The first official release of AT&T timing advance data was not provided to law enforcement until June 15, 2023 by GLDC. In 2022, the FBI obtained AT&T timing advance records from another source outside of GLDC. AT&T timing advance records in the state's possession. During this investigation, law enforcement obtained the following AT&T timing advance data. A, 2 of the victims had AT&T phones. Law enforcement obtained both of the data on both of their phones.
Okay, which again, within a 7-day period, but go ahead.
Law enforcement developed an early investigative lead in this case. That person had an AT&T phone at the time of the crime, and law enforcement obtained his AT&T timing advance data.
Keyword, early investigative lead within 7 days? Okay.
Law enforcement also requested a tower dump consisting of AT&T timing advance data. This request involved AT&T providing all the connections between 2 specific cell sites in Moscow during a 2-hour period. The data produced was AT&T timing advance data. In all, there were over 3,800 AT&T mobile phones identified in the timing advance tower dump data.
Okay.
What
2-hour window, okay.
Because
his phone was disconnected.
Right. Maybe like between,
let's say it's 3 and 5. His phone was effing disconnected.
I know. The AT&T timing advance data was obtained by the FBI using an internal source at AT&T, Mr. Boyd Jackson, who's not associated with the GLDC working group. GLDC was not used to obtain this data. A forensic examination of the AT&T timing advance records in the state's possession show Mr. Jackson's association with the reports. There is work product in the state's possession, created by the FBI, showing the AT&T timing advance data was not only obtained, but regularly referenced and used in the course of this investigation. Its existence is well known to the investigators and prosecutors.
So thank you so much. Yeah, thank you so much, Kimmy, for the $5.55. You ladies are amazing. Thank you for all you do. Thank you, Kimmy. And I didn't know you popped down, Wolfie. So it says the chain of custody. 1, the state has provided a certificate of authenticity, which they did for basically everything, guys, to defense in relation to the timing advance records described above. The COA was created in April 2024 and issued by the director of GLDC, Stephen Gordon. 2, I have previously worked with and I'm familiar with Mr. Gordon. 3, the COA specifically states, quote, I am qualified to authenticate the records attached hereto because I am familiar with how the records were created, managed, stored, and retrieved. 4, I have personal knowledge that in the event Mr. Gordon was required to testify, he would clarify that prior to May of 2023, neither he nor the AT&T GLDC working group was involved with AT&T timing advance records. 5, additionally, there is forensic evidence contained within the records that indicate they were not produced by AT&T GLDC, nor were they produced in the year 2024. 6, in retrieving this data, I contacted and communicated with Mr. Gordon to clarify the chain of custody related to these records. Mr. Gordon and an AT&T legal representee informed me that Mr. Gordon would not be the individual to certify these records if required to do so despite issuing the COA. 7, in my review of this information, there is evidence to suggest the chain of custody involving these records and the COA were produced well outside of AT&T's normal practice. There is missing information and data associated with this request. The prosecution's prior claims that AT&T timing advance data did not exist in 2022 further complicates this issue. It is my expert opinion that any testimony proffered on behalf of the FBI or AT&T on this matter would clearly reveal these issues. So evidence in direct contradiction to the state's motion include 1, In my review of this investigation, I have read numerous emails sent and received by law enforcement pertaining to their investigation. 2. One such email dated November 15th, 2022 was sent to Prosecutor Ashley Jennings at her Leda County government email address. This email is from the Moscow detective Lawrence Mowry. This email is informing Ms. Jennings of Detective Lowry's recent contact with FBI Special Agent Balance. SA Balance informed Detective Mowry that AT&T can provide timing advance data and to make sure it is listed in the search warrant. Detective Mowry is specifically asking Prosecutor Jennings to make sure the AT&T timing data is listed in the warrant prior to the report ever being distributed by the working group known as GLDC. 3. Mrs. Jennings did respond to Detective Mowry's email inquiring on the specific verbiage needed to obtain AT&T timing advance. This email is abundantly clear evidence that Mrs. Jennings was not only aware of the existence of AT&T timing advance in 2022, but also shows her intentions to obtain it through legal process from AT&T. 4. This email communication with Prosecutor Ashley Jennings is the same Prosecutor Ashley Jennings who filed this current and contradictory motion, stating AT&T did not produce timing advance records in 2022. 5. There is clear and convincing evidence that not only was the FBI able to obtain AT&T timing advance records in 2022, but they did so with the knowledge of the prosecutors involved in this case. So the missing AT&T timing advance, 1, in my review of this investigation, based on my training and experience, it is incredibly unusual that Kohberger's AT&T timing advance records were not obtained by the FBI. 2, the FBI demonstrated their ability to obtain AT&T timing advance in November 2022 by obtaining AT&T timing advance records on over 3,800 mobile devices, none of them being the defendants. 3, when it comes to location data from AT&T, timing advance data can be some of the most accurate data available. Additionally, it contains connections to the network other than the typical voice, text, or data connections. This allows law enforcement to not only see more data, but more accurate data. Anytime a defendant's locations are in question, a timing advance report would be asked for a standard operating procedure. Moscow Police Department, by the way of the FBI and with the knowledge of prosecutors, demonstrated their awareness of this standard procedure when they obtained AT&T timing advance data on over 3,800 mobile devices. 4, when detectives and prosecutors requested and served 2 different search warrants to AT&T on Kohberger's AT&T account, they requested the exact same timing advance data they previously did when they obtained timing advance data from AT&T on over 3,800 mobile devices. They also maintained the same process in utilizing the FBI to serve the legal demands on AT&T. There is no difference in the verbiage, legal process, or individuals that produced AT&T timing advance data on 3,800 mobile devices and requests for Kohberger's AT&T timing advance data that allegedly yielded nothing. 5, additionally, on December 23, 2022, the FBI sent a communication directly to AT&T specifically detailing their request for Kohberger's AT&T timing advance records. There is no reason to believe AT&T would not respond to this request. 6, it is my expert opinion AT&T timing advance data did exist for the Kohberger's AT&T mobile device in 2022, and it was requested from AT&T by the investigators involved in this case. The investigators previously demonstrated their ability to obtain AT&T timing advance data in 2022. Failure to produce Kohberger's AT&T timing advance data is either a gross deviation from standard practice or intentionally withheld from release and discovery. So the conclusion is, 1, it is my expert opinion in reviewing all of the evidence that has been disclosed by the state that A, AT&T timing advance data was available on Kohberger's phone in 2022. B, there is overwhelming evidence showing the state obtaining and using AT&T timing advance data in the course of this investigation in 2022 on over 3,800 AT&T mobile devices other than Kohberger's. C, there is no doubt the author of this current motion, Prosecutor Ashley Jennings, knew or should have known AT&T timing advance data did exist in 2022. She was directly involved in the legal process obtaining it and was aware of work product created from it for further investigation. The current motion is a deliberate misrepresentation to the court to further conceal false statements used to obtain probable cause against Kohberger and conceal exculpatory evidence from discovery. 2, I'm prepared to provide witness testimony, relevant exhibits that support all of my opinions contained in this affidavit. It is my belief this evidence is beyond clear and convincing and will be supported by any competent expert in this field who reviews all the data. This is not a battle of experts. The evidence supporting the opinions in this affidavit is overwhelming. 3, in my nearly 30 years of working with and for prosecutors all over the U.S., I have never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in possession of the state and defense. It rises to a level beyond a simple miscommunication or oversight, and it is clear an intentional misrepresentation in the hopes to conceal a much larger issue. I respectfully request the court give this affidavit the due attention it deserves and explore these issues further. Cy Ray. Woo! Oh, man.
I know.
Hot damn. That is, okay. What I'm struggling with, and hello, Shacto, King Scarlet, Seven Lilies, Big Star. Hello. Yeah, it's worded strongly. Okay. I remember him specifically saying he reserved his right to change his mind. Yes.
Right.
Here's the thing I'm confused about. Timing advance records existed, but it's a 7-day retention. And I agree with Harlot and hi, Nikki, there's an issue because if they're saying it didn't exist, it existed, but it only the 7-day retention period. So it's like you're going to get hung up on words there a little bit, which I get that argument, but this was already explained in their motion in limines back and forth that wait, hold on. Let me be clear. It existed at one point, but they were way beyond the window to obtain it. Now, it doesn't surprise me that when they got to Kohberger, they requested it, but it wouldn't have existed because it's way past that 7-day retention.
Mm-hmm.
What are your thoughts?
That's exactly my thoughts right there. I'm stuck on that 7-day retention. Like, what is the miss here? I went back over to the state's self-authentication records and went back down, and I was trying to read through the AT&T stuff that we went over and found that, last paragraph about that 7-day retention. And
yes,
it makes sense to me. Like, yeah, of course you're going to have some timing advance for the area. But if his phone was off the network, then he may not be included in that. And what other information that balance will be going over? See, we weren't part of like the grand jury and all that shit to see what evidence was turned in. So I'm kind of confused at this point.
I'm a bit confused too, because again, and that's what I think, Harlot, they didn't mention that 7-day window until their most recent filing. I wonder if the defense used an earlier affidavit without updating him, because he went hard in this. Mm-hmm. But they got 3,800. Okay, so here's the thing, Tiffany. They got 3,800 others because what they did is they took a 2-hour window. Yeah. And they took that immediately, okay, within that 7-day window. Within these 2 hours, these two utilizing the Moscow network, right? What AT&T phones connected during these 2-hour windows, and they got that AT&T advanced timing from those. Kohberger was not one of them. He had disconnected from the network. His phone would not be pinging from the Moscow between the 2 hours, which we could assume are the 2-hour window before and after the murders, right? His phone did not connect to the network until after and out of Moscow, okay? So I wouldn't expect to see him there. So the fact that they got it from 3,800 phones isn't surprising to me. But by the time they got to Kohberger at the end of December, it would be way beyond the 7-day retention window.
Right. I feel the same. Like, I was like, I don't understand what the miss is here.
Yes, exactly, Vicstar. Okay, can I tell? He seems legit based on paper. I could tell you this.
Oh, the Colorado ruling, like he's already been admonished in court.
Exactly. He's already been admonished in court, and the places that he has gone on panel for, I'm sorry, but that's a huge factor to me. That's the fact that you would ever land yourself on a channel like you've landed yourself, especially prior to trial, that is very telling to me.
Right.
Yeah, he thought he left no breadcrumbs, yet everything he just basically said, this is what people need to understand, is not going against what prosecution is stating in their most recent filing. Hey, yes, they did exist. It's not that they didn't exist, period. And yeah, they should have clarified that earlier on, okay? But it didn't exist for his phone at the time that we asked for it, at the end of December. It didn't change until November. I'm sorry, not November, whatever month, 2023. I'm not promoting that skadoosh. Sorry. Respectfully, I'm not promoting that channel. So here,
and I put an article in there from the Colorado one where they said that the cell phone back.
It's subscribers only content. It won't even let me.
Oh shoot. Never mind. We've gone over it here. I can pull it up.
Yeah, we've gone over it before.
Basically, a Colorado judge ruled that the methodology that I guess that they were using wasn't accurate for the cell phone data, Cyray's company, and that I think something about he listed in his CV that he was an engineer and he's not an engineer, something of the sort, but don't quote me, but those are like the top two things I remember from it.
Yeah.
And if you're like kind of deemed unreliable in the court system as an expert witness,
that's bad.
Other trials and courts, they can use that against you and bring it up.
Yes, they can. And so the first thing that if they pull him up as an expert witness for a defense, the first thing that they're going to say and state is it true that you've been discredited as an expert witness in the Colorado court? And go through the reasons of why. And so, take that for what it is. And welcome, Vicstar. Thank you for becoming a member.
Yay.
Defendants.
But yeah, he did seem so certain in that, Melissa. I was wondering that too. Like, wow. Like, And I want to know more. I mean, hey, if he's got this secret ticket that says something different, tell me all about it.
Right. But unless he can, are you going to pull out the timing advance records? Are you going to show Kohberger wasn't at the murders at that house? Are you going to prove that? What are you going to prove?
That the evidence is stacking circumstantially. I mean, how do you still explain away his DNA on the knife sheath?
Well, no, for real. Is he going to prove his phone wasn't where it was supposed to, like his phone was elsewhere? Is that what he's going to prove?
I mean, that's his partial collaboration of his alibi. It is the most mysterious thing I've ever seen before. It's like this big thing with Cyray, but you're not telling us how it's going to be exposed.
Right. I have sources. I have this. Okay, great. Prove Kohberger's phone was not in the area of the King Road house at the time of the murders. No, they showed, and I would pull it up if it let me pull it up. I know we've gone over it before, but no.
I didn't go that far into it. It's been a while. It's not so much I get people can get things wrong, technology can advance. But whatever this ambiguity here is, I am certain Judge Hippler will work it out before the hearing, because this would just be sidebar after sidebar,
Yeah. Absolutely. And thank you, DB Bentley, and hi. What I didn't hear in there is mention of the 7-day retention window at all.
Right.
At all. Yes, it existed for his phone. It's not that timing advance records did not exist. They did not hold on to it. So the timing advance records for Kohberger does not exist, because at the time in December 2022, they only held it for 7 days. November 13th is the day of the murders.
Right.
December 29th is when he was arrested. December 19th is when he first came onto the radar.
Now, if we find out that they expanded those records, Melissa, outside of that 2-hour time frame, and say it was around the time they're suggesting that Bryan around 9/12 came back,
Yeah.
and they did it within the 7-day retention window, then I do think that there's a serious problem, but I haven't heard that yet.
No, they specifically said none of the 2800 or Bryan Kohberger's phone. Okay, nor would I expect it to be if it was at a time it was disconnected from the network and not in Moscow. Are you serious?
Yeah, this is kind of like look the other way kind of strategy, in my opinion, right now.
But people are going crazy over it.
Right. Because this is one thing that's held on to, and then everything else is explained away. Like, we went over the crime scene final, and I get it. It's a report. I found it really interesting. But why is it relevant to Bryan? Because he had the knowing state of mind about crime scenes and investigations and things to do. Like, it's easy to just give a small explanation, but it's the mounting of the evidence.
Exactly. So, and that's what I was saying, King Scarlet, when we went up, and it was like 2 of the victims' phone, they got it for it. Yeah, because they knew the victim's day 1 within the 7-day window, they got it. Then there was a early on lead. They have his, yeah, an early on lead within 7 days. They were able to get it. They didn't get to Kohberger till the end of December. Like, what do you mean? It like you're solidifying what they're saying. There's a freaking 7-day window. I think they're getting hung up on saying it didn't exist. No, it existed in 2022. It just didn't exist the way it exists now as far as it being stored.
Right. And I tried to find like some stuff for us to go over, but this really hadn't been talked about since Cyre's like last testimony, and now we have a lot more information, so it's not as relevant.
Mm-hmm.
But yeah, well, that's definitely getting debated.
He's not wrong, Skadoosh, but it's not, he's not accounting for the retention, the 7-day retention, like that. He's acting like they never addressed it, unless he didn't see the most recent motion, which, what day did he sign this?
On the 25th, and the state's motion
was
with
on the 21st.
Well, the 24th was signed by Gordon, and that was uploaded on the 24th. So yeah, he had a day to review it.
Unless he really didn't freaking know or something, which I highly doubt.
But he says he reached out to them, and that the COA, that Gordon wasn't going to be able to be the one to authenticate it on court record. Yeah, because it's like page 17 of the state's reply. I just was going back through that again. And they're specifically talking about Bryan's phone, not the victim's phones.
Right. They're specifically talking about Bryan's. But again, there is nothing wrong. If there's a 7-day window, Bryan's phone was disconnected from the network during those crucial hours. It wouldn't be in Moscow pinging because it's disconnected, and we know his path of travel, and he wasn't there anymore outside those 2 windows, like the 2-hour window.
And I think the state, was smart with trying to even track the cars. I know we've talked about it, but like when we were going through the authentication records, Melissa, as I've had some time to process, I think it was smart that they got him getting out of his vehicle and entering his vehicle, like putting a face to the vehicle so that they're tracking. Like, I do think that they were very methodical in what evidence that they had at their hands to put 2 and 2 together. I don't think that they would go forward with something if they had a doubt of he was the person.
No, I agree.
You risk way too much.
Yeah. Hi, Meat Feets. Hey, MS girl. Okay. So now we have the notice of filing declaration in support of defendant's objection to the state's motion in limine regarding the demonstrative exhibits and memorandum of support. So you remember this, the Barbie house, as Shay calls it.
I do.
This is
still like
the declaration of Matthew Nodal. So they're bringing on their own guy. You want to explain it? Go ahead.
Okay, so if you guys were here with us last time, we went through the roller coaster of events where nobody wanted to have the 1122 King Road house standing. Everyone wanted demolished. Prosecution, defense, court didn't interfere, even though some families wanted delay. It's down. So then here comes both sides, had access to the house for a significant amount of time to do surveying for models, and they knew that the FBI was working on that. The prosecution comes forward and they're going to use this Barbie house model, and it's not supposed to be to scale. And now apparently they want it to scale, so they're going to bring in Matthew Nodal here as a person to help bring it to scale. And it just seems like it's like, it's a roller coaster. It's like, what do you really want, Anne? Do you want it to scale, not to scale, to scale?
And don't forget the email exchange between prosecutors and Anne saying, hey, we want to do this 3D model that, we have 2D, 3D, blah, blah, blah. And she's like, yeah, I'm not happy with that. And they're like, okay, we know you're not happy with this. What can we do in order to fix this, right? We see that you're already planning on filing a motion and objecting. So how can we incorporate this for it to be to your satisfaction? And she's like, nothing. I'm gonna object either way. So destroy the house. No objection here. Put up the model of the house. Not happy with the model because it's not literally, what is this? A center for ants? It's too small. It's not to scale exactly. And he's like, the only purpose of this is for the jurors to be able to have a visual for when a witness is testifying and saying, hey, Dylan, right? I came out of my room. Is your room here? Yeah, not for any other purpose than that. And she's just not happy with it. So now they have their declaration and affidavit of Matthew Nodal. And it's just, go ahead, you could read.
Well, I mean, I kind of find it, I was wondering if this was almost a taunt to Bryan after reading over his crime scene stuff, Melissa, because everything to him was scale and detail. So could it be Bryan having Anne push this to scale, kind of, you know what I mean?
Yeah.
Because of the detail. He needs the detail. It has to be right. Okay, sorry. I, Matthew Nodal, swear under penalty of perjury that the information in this declaration is true and correct to the best of my knowledge. My name is Matthew Nodal. I'm an adult over the age of 18. I have personal knowledge of the facts set forth in this affidavit. I'm a forensic scientist with degrees in microbiology, medical technology, and forensic science, certifications in firearms, tool marks, gunshot residue, and laser scanning. My total experience includes over 38 years working exclusively in forensic science as outlined in the attached CV. Sounds very qualified. I've been retained as a consultant by the defense in Mr. Kohberger's case. One of my key roles in the case is to assist the defense team in investigating and reconstructing the scene. During the course of my work, I have had the opportunity to observe the scene. I conducted a 3D scan of the scene at the first opportunity provided to the defense. The purpose of 3D scanning a scene is to understand and depict the way a scene appeared and be able to troubleshoot that scene in a to-scale manner. It is imperative to acquire the scans appropriately and stitch together the scans accurately to ensure they meet evidentiary standards for further troubleshooting of the events. I am aware that the state has conducted at least one set of scans that depicts only the 2 rooms with the deceased in situ acquired in the first hours of the investigation, and a report that indicated a second set of 3D scans was acquired on or around November 1st, 2023, but that data has not been produced until recently, March 14th, 2025. Prior to March 14th, I have been provided with only the early scan data that depicts 2 rooms in the house. Recently, I was made aware that the state had intended to use the previously unproduced data from the second set of 3D scans to build a replica model of the residence and associated topography for trial. I have only recently been provided with scan data and have not seen the final product, model, or other data the builders of the model intend to rely upon. I have not been provided with the details as to how the data from the 3D scans will be incorporated into a demonstrative model or how the model may be used in presentation to the jury. I have concerns about any replica utilized for trial that has not been verified as to scale, given the layout of the house and misrepresentation of where a wall is or where a door was located or what the actual line of sight was will be misleading and could cause a jury to place significance on something that is not accurate. Utilizing a replica that is not to scale will invite speculation and confuse the jury.
Okay.
In addition, I've been informed that the model will not have any furniture, original materials, or other objects that take up space in the normal layout of the residence. The absence of these features can influence the appearance of spatial relationships as they actually existed and were captured in original photos and video. While it is unclear at the time that the intended use of the model, these are the concerns I currently have incorporating such a model at this late stage of the event analysis. Finally, on March 14, 2025, I was provided with the data from which the model will be built. This data includes over 100 individual 3D scans that have been stitched together and include not only the residence, but the topography of the surrounding landscape. Assessing this data will take considerable time, and then examining the finished product and verifying scale, dimension, and completeness will take additional time on top of that. Does Dan need more time? Is that a more time plea again, Melissa?
Got some more time.
By way of reference, it will take at least a full day, if not more, just to download the data from the server. Well, you better get started, man.
Going. Yeah.
Come on, buddy. Once the download has been completed, the analysis will take approximately 1 or 2 days to assess the scan data. After my analysis of the scan data is complete, I will need to arrange a viewing of the exhibit and a description as to how the scan data was translated into the actual physical exhibit needs to be provided. Traveling to examine the model created and documenting what may be needed to further assess it are the things that are not built into my schedule at this time. I will need to schedule this additional examination around other commitments previously made and find time to travel from the Seattle area to wherever the model is sorted approximately 1 day, and then assess and document the model on a second day with return travel later that day. The earliest available times for such a turnaround, given my schedule, start around the week of April 7th, which hit and miss appointments and testimonies scheduled within that time frame. So we're trying to push out the next court date?
Yep. That's exactly.
I heard it.
Right. That's a good point. Yeah. Infinite time, please. Thanks, MS girl. Yeah, be safe, Shakto. Anyone in the area of bad storms.
Yeah.
So this is bouncing off the Ray stuff, and it's the vague and undisclosed expert testimony. And this is defendant's response. Well, defendant's notice of filing the affidavit. And so it's in support of affidavit of Ray, which we had just read in regards to AT&T timing records. And it states, let's see, we have another affidavit. Ray. To avoid repetition, please refer to my training and experience. Thank you. So in preparing this affidavit, I reviewed the motion in limine number 2, vague and disclosed expert testimony filed by Kohberger. I reviewed all of the state's responses in reference to this motion, as well as SA Balance's draft report and final report. I am addressing the matter of FBI Special Agent Nicholas Balance's anticipated testimony in this affidavit and what has not been disclosed. I have reviewed the initial reports, final report, first discourse, second disclosures, and now the third disclosure. Despite this progression of disclosure, SA Balance's opinion on the relevant issues at hand still have not been disclosed. 6, I reviewed disclosures in reference to SA Balance's interpretations and opinions relating to AT&T qual detail records. They are vague and at times contradictory. At this time, I am unable to identify his methodologies and or resulting opinions on most of his work, preventing me from any real analysis to determine the basis of his opinions. 7. The disclosures in reference to the facts and data relied on SA balances to form his opinions regarding AT&T cell detail records are conflicting and void of substance. His work does not contain his methodology other than a paragraph. He does not mention AT&T, handoff data, drive test mapping, or any other critical methodology required in this analysis. The report does not provide explanation why SA balance may or may not rely on AT&T data, preventing me from any real analysis of his opinion. 8. I regularly work as a subject matter expert, and it is standard in my field for expert opinions to be well documented and based on accepted best practice or a methodology. The facts and data relied upon to reach an opinion are known and disclosed. SA Balance's work is a departure from the field standard. He has not disclosed his methodology and analysis for his opinions. This is partially what?
I think it should be known too, if chat's wondering, like, a lot of this stuff is under seal, so we don't know what's turned in.
Yeah. This is partially due to contradicting methodologies that have been disclosed. B, this is partially due to vague work product absent of any real substance as to facts and data. C, this is partially due to changes that evolved through irritations of work product without explanation and documented by facts and data as a basis. 9, I did note that SA Balance has a dual role in this case. He is an expert witness for the state, and using these same skills, he was involved in the actual investigation from the onset. He was co-located with investigators throughout the investigation. His opinions and interpretations were relied on by investigators and prosecutors. These interpretations and opinions found their way into every probable cause statement supporting search warrants against Kohberger. He is referenced in nearly every search warrant issued. His opinions and interpretations were an integral piece of building probable cause against Kohberger. Unfortunately, most of his opinions and interpretations provided to investigators and prosecutors are not supported by the evidence in this case. B, it is this very reason I was awaiting SA Balance's report detailing the facts, data, methodology, and analysis relied on to make such egregious errors. I expected to see work that explained the conclusions as well as properly addressing omitted analysis and errors in the work. C, the omitted work in this case is exculpatory to Mr. Kohberger. Oh, really? I hope you plan to bring that. The intentional omission of exculpatory evidence, which they're not allowed to do, guys. 10, SA Balance did not include analysis of AT&T handoff data provided by AT&T for the defendant's mobile device on the 13th between the hours of 2:30 a.m. and 3 a.m. 11, the handoff data in Kohberger's AT&T records during this time is exculpatory to Kohberger. 12, SA Balance did not include an analysis of AT&T data regarding 23 time periods in his report that he appears to be suggesting Kohberger was at or very near the crime scene. This opinion appears to be based off cell tower connections, primarily handoff connections in Kohberger's AT&T records. B, it is difficult to determine the process of methodology SA Balance relied on to suggest this connection for several reasons because the AT&T records do not support the statement. C, there is no report.
But we were expecting, I wasn't expecting Balance to put Bryan there during the crime because of what we know. Like, am I missing something?
You gotta say that again. I was reading Harlan's comment because I was laughing because she's like, I expect his full name to be like Cyrus the Virus.
I was laughing at it too. No, I'm saying, like, I never expected Balance to put Bryan there during the crime based on the data. So are we having this fight? Really?
And I don't think it's unusual that SA Balance is mentioned in so many. He was a lead FBI guy. Like, what do you mean?
For like, yeah, and the forensics of stuff. Yeah, absolutely.
Right.
Well, yeah, and we have Michael Douglas that did all of the bank stuff, and Balance did all of the phones and cast and stuff.
Yeah. It's not, I don't know, like,
I just feel like the way that things are being.
yes. Sorry. Yes. Why didn't that's what I'm saying. I hope you plan to bring it. If these were accessible, I hope you plan to bring it.
I think they're just trying to attack everything right now.
Yep.
And I get it. Like, and if there's anything that's not done to procedure or is against Brian's constitutional rights, like, let it be known. Work through this.
Yep.
Sorry, I didn't mean to like derail you there, but
no,
I'm
you're
just like, when
fine.
we're reading that, I'm like, we're doing this again in a different way. Before it was the 7-day window. Now it's like, you can't put him there at the crime. And it's like, of course you can't put him there. That's
right. And that doesn't go against their narrative, but exactly, Nika, especially if it's exculpatory. And for anybody who may not be familiar with what exculpatory evidence is evidence that is not in favor of prosecution's narrative, that would actually point away from being Bryan Kohberger, right? Exculpatory evidence. And so they have to hand over exculpatory evidence. They have to hand over everything. And that is why we heard, if you guys remember back regarding those unknown male DNAs,
You're on my brainwave.
Yeah, we provide, like, you're using this against us. Meanwhile, we provided this as exculpatory evidence. Hey, these unknown male DNAs were found. Hey, we can't conclusively say it's Kohberger's. Exculpatory evidence, right? And so evidence that is not in favor of it being Bryan Kohberger. But they would get into major trouble if they held back exculpatory evidence and didn't give it to defense.
Yeah, and I know. Yeah, and I know in some of the phone like warrants, when I read and got into them deeper, they missed some redactions. But Jack was looked into, Kaylee's love, and so they obviously would be providing any kind of evidence of what they were able to get in tips, what they were able to rule out. So yeah, I don't really understand why we're expecting Balance to put him there at the crime. We're not. Right. But okay, Sai.
Okay, Sai. If you're paid enough, So 3, there is no report or analysis detailing Kohberger's movements between June 2022 and December 2022, which would be needed to surmise that Kohberger's phone was at or near the crime scene 23 times prior to the homicides. 1, there is no mapping showing the network connections relied upon. And 2, there are no drive test coverage maps of the other than one cell site. 13, a recent disclosure about what SA Balance may testify to reads, quote, handoffs are mapped on a case-by-case basis, which is determined by the needs of the investigation, end quote. From my experience as a subject matter expert in this field, this claim is outside of any established best practice or reliable methodology of analysis. The standard is that all data must be analyzed and considered, regardless of how it impacts the investigation.
Wait, let's go back up, because I think that I just want to break this down, because I do think this is important. Think about time. They have so much data. And when I'm looking at how Balance may testify, handoffs are mapped on a case-by-case basis. Of course, they're going to have tons of sets of data, Melissa, and they're going to analyze it. But what's getting mapped is based on what was analyzed. So right. I don't think that's a fair statement. I don't know about you, but that's my interpretation of it.
Absolutely. Hey, Jones, and it is nuts, Jones. It is crazy. But I'm really starting to see people's bias. I'm really starting to see it showing.
Yeah.
Well, no, Shelly, because here's the thing. They're going to go for the opinion that works for them, right? So they don't want to get necessarily a second opinion that would go against what they wanted to go. They're like, this is the exact opinion we want. You know what I mean? Mm-hmm. Like this is exactly, they're going to go for the opinion that works for their narrative, same way that prosecution is.
Mm-hmm.
Okay. So 14 says go ahead.
You want me to review or you got it?
You go.
Okay. I have reviewed the disclosures about what SA Balance will testify to and do not find the disclosures provide further analysis to support his opinions. A, the first cell site recorded in this session is the only cell site that is chosen based on the measurements made by the cell phone representing the best signal from these measurements and ranking of surrounding cell sites. Okay. This theory can be disproven with the AT&T records themselves. This response does not explain why he would use handoff data at certain times while ignoring it at other times. B, the coverage maps are created using the actual measurements taken by the GAR and interpolation using the natural neighbor algorithm. In other words, it's looking at known values at known locations to determine the expected value at a location where a measurement could have been taken. The natural neighbor algorithm was first published by Robin Simpson in 1981, and it was widely accepted in both academia and as an industry standard in determining the coverage of a particular cell site within a broader cellular network. This statement falls well short of any real disclosure of how the GAR product estimates cell site coverage areas. I've been in direct contact with Gladiator Forensics, and this statement contradicts what Gladiator Forensics communicated to me about their own products. Hey!
Hi.
C, a recent disclosure states page 13 depicts cellular phone usage by the 8458 phone on November 13, 2022, and Balance is expected to testify that when the 8458 phone interacted with the AT&T network at 2:47:29 a.m., the phone was not at the Bryan Kohberger residence marked BK on the map. Rather, it was southeast of the Bryan Kohberger residence as depicted by the drive test data. Balance is also expected to testify that he analyzed additional handoff data that occurred during this data session and that the 8458 phone stopped communicating with the network at 2:54:45. And remember that discrepancy even Judge Hippler had mentioned in his Frank's hearing. He said it still gives Bryan enough time from when the crimes were committed if he was going a different way to turn around and go back and do the crime. It could have been done strategically.
Correct.
So this disclosure does not provide an analysis or opinion as to what SA Balance found when he analyzed the additional handoff data that occurred during this data session. This is the very data I previously testified about having been omitted from SA Balance's work product and opinions. 15. SA Balance conducted a significant amount of drive test data. They did just provide this, right, Melissa? Didn't we go over that?
They did.
Okay, has not provided that data to support his network. A, drive test data is collected when an investigator takes radio frequency survey equipment out into the field and collects signal measurement of the cellular network by driving specific grid patterns through an area. It is possible to capture enough data to reliably estimate a cell site's coverage area. In this case, SA Balance and SA Kennedy spent several days conducting drive tests in and around Pullman and Moscow. In all, they collected well over 500,000 data points. Wow.
Wow.
Why do we spell that out? Why don't we just show it written as a number? Because that would definitely pull to your eyes, right?
Yeah.
Enough data points to effectively map the coverage areas of all relevant cell sites related to this case, that being roughly 24 cell sectors. SA Balance has only produced coverage mapping for 4 sectors. SA Balance has collected the required data and does have access to the required software to map all of the sectors he analyzed in his drive test efforts. The conversion of raw data to a coverage image is relatively non-existent when compared to the effort required to collect the raw data. 16. SA Balance, in according with FBI CAST policy, had his work product peer reviewed by another FBI CAST agent, SA Kennedy, which that's normal. There are official reports stating SA Kennedy did peer review Balance's work product and signed off as it being complete and accurate. A, I created the first subject matter expert certification course in the United States in this field for state and law enforcement. Oh, okay, sorry, toot your horn. I've taught this course for over a decade, certifying over 100 subject matter experts in this field. Okay, but you're not the FBI or Secret Service for that matter. Okay.
Nope.
Part of that course includes the peer review process. The standards in the field dictate that data must support a peer review. I have personally completed well over 50 peer reviews myself, and the state does not disclose the required data to support a peer review of Balance's work. So this is my thing. What if some of the work that they have, what if some of it is withheld, Melissa, because it's not pertinent to this case at all? Like it's other people's, like
Totally plausible.
yeah, like what? Because there, like, what if there is kind of some safety concern in that aspect? Like I don't know. I'm just kind of thinking through like a little bit of why maybe some stuff would have been withheld.
Mm-hmm.
Because you would turn over to discovery what's relevant, obviously what's exculpatory, but if Bryan's data isn't in some of this, then why would you turn some of it over? Well, I guess, yeah, for exculpatory, I get that, but sorry, I'm just...
Yeah, but not if it had to do necessarily, I see what you're saying. If it had to do with things that have nothing to do, these people have no involvement type of deal. I don't know, is that specifically exculpatory? I don't think so, unless something jumps out specifically about it. Hold on, I'm running to the restroom.
Yeah, you're fine. Go for it. Oh, this is wild. What do you guys think? Blackthorn defense obviously thinks the judge isn't smart enough to understand that that's a mistake. Honestly, I am all for a good battle of the experts. Don't get me wrong. Like, I'm especially looking forward to it in the Reed trial, the Reed trial coming up. King, I think he's referring to the data that doesn't exist because the phone was off. Yeah, but see, King, this is one of the things that has really gotten to me is I'm not convinced he didn't try to overwrite data that was on the phone itself as well. Like, you know what I mean? I am concerned with that a little bit. That's why I was saying, like, if he had such experience in like cloud forensics and stuff, like they need the best of the best forensics team to review anything that they're going to say is exculpatory and puts them elsewhere. A neat noodle. It's not a Brady violation if the data isn't relevant. Okay, neat. Yeah. I was kind of thinking maybe like, when we were going over some of the IGG stuff, how like the state was like a little bit more apprehensive, obviously, to release information on like 10,000 sets of data. And then you had the judge kind of take an in-court camera review and review it and come up with a decision. That's kind of what I was thinking. Like maybe there's a lot of data that's not necessarily need to be known. Shelly, he logged onto the VPN to overwrite that data. Oh, Shelly, interesting. I want to know why he logged into that backup account on the VPN. What was he doing in there? What did he do?
What did he do?
What did he do? And I will tell you guys, if y'all, because I know you got to run to your other live, but
well, I want to do another one first.
Okay, but you guys have got to be checking out some of the Facebook groups. I am laughing my butt off at some of the memes that are going on in there. It's like people have stepped up their meme game, Melissa, real hard on this case.
Oh, I'm sure.
The memeing is memeing.
So
and I love a good meme.
Yeah, I know. This one is just ordering to seal the text message and testimony and Mr. Roloff's affidavit. Okay. Redacting, personal information, including Bethany and Dylan and numbers and names of the victims. Only initials. So that's that one.
Mm-hmm.
Let me see.
There's some that we didn't get through that.
I know.
We're in that older pool. I don't know if we want to take one.
That's what I'm looking for. Like, what?
Like, what's a good one? I feel like a lot of the meteor stuff we said we were going to have to jump into would be some of the DNA experts and some of the autism things. Because those are really long.
Yeah, those are really long. I don't think we did this one regarding the state's replied to the defendant's objection to motion in limine regarding the immediate family members in the courtroom. So they filed it March 17th. I remember reading the original, and it says the state is in agreement that immediate families should logically include step parents and relatives by marriage. Kohberger stipulates to the individual list within state's Exhibit S1. Remember, we went over that. Therefore, the state moves the court for an order allowing the family members listed on state's Exhibit S1 to remain in the courtroom during the entirety of the trial against Kohberger. Regarding courtroom decorum, the state defers to the court's, quote, inherent authority to supervise their officers, parties, witnesses, counsels, and jurors by imposing rules to protect the right of litigants and the orderly administration of justice. Kohberger requests that members of his family be granted the same rights as the victims' families. However, the, quote, immediate families of homicide victims have constitutional and statutory rights to attend pursuant to Idaho Constitution, Article 1. There is no comparable constitutional or statutory provisions affording a defendant's family these same rights. Further, there is no authority to support the argument that Kohberger's Sixth Amendment right would be violated. Kohberger has a constitutional and statutory right to a public trial, but that does not extend to Kohberger's choosing whom sits in the courtroom. In addition, the state may call member or members of the Kohberger family to testify at trial. Prior to the start of trial, the state anticipates it will motion the court, or the court will on its own accord generally exclude testifying witnesses from the courtroom so that they cannot hear other witnesses' testimony. Kohberger's family are not exempted from IRE 615. Therefore, those members of Kohberger's family on the state's witness list due April 21st, I'm so excited, should be excluded from the courtroom until they testify.
Yeah.
I'm really thinking that they're
going to ask him about the Amazon stuff.
Yeah, I'm thinking that family may have alerted something. Not dad, I think sister alerted. That's why we got the wind of it back then.
I mean, that's kind of what I was saying, like on the Dateline episodes that have been pulled down, that was one of the things that was talked about on both of their episodes, Melissa, was that a source says that a family member, perhaps sister or Bryan, had reported him on top of what the FBI was already doing in terms of their IGG investigation. Gotta wonder why it's been pulled down. Is there some truth to it? What you want to do?
I'm trying to look.
I made a spreadsheet of all of the documents and their links and organized it. I started getting organized. There's too much.
Okay, hold on.
Oh, and Melissa, I did find that big document thing finally that I was telling you about, but it wasn't the exhibit map. It was the one of all of the, remember the pre-trial survey that they did to move the trial from Latah County to Ada? It was in one of like the documents of the defense, and like she included like all of the questionnaire and the answer, and then she had like all of the MPD, Moscow Police Department updates in there. It was really interesting to see it kind of evolve as now that we've gotten more information out.
Yeah, absolutely. This is the order denying witness testimony at this upcoming April 9th hearing. So you want to read this?
Yeah. The court, having before its defendant's motion for leave to allow witness testimony at April 9th, 2025's hearing, has determined that witness testimony beyond declarations is not likely to be necessary for the court's consideration of the issues before it. The information defense seeks to convey can be presented by declarations. Counsel may have the witnesses available by video streaming during the hearing, and should the court determine it is necessary to hear from the witness, the court may allow such testimony by video live stream. It is hereby ordered that the defendant's witness, Cy Ray, which she said Cy Ryan and David Howell shall not be allowed to testify at the hearing being held on April 9th through 10th, 2025, unless the court determines at the time of the hearing that such testimony is needed, in which case it may be produced by video live stream. So that's for cell phone and Amazon clicks.
Mm-hmm.
That was the judge's order. So he denied. And then that's like right after he did this denial is when it started being hell on water.
Okay. This is state's reply to defendant's motion in limine 11 excluding IGG evidence. Ready. So the state will be meeting with its prosecution and investigation team to identify who will testify about the receipt of a tip on or about December 19th, 2022, and the subsequent actions taken by investigators and the state and advise court and counsel. It is unclear what Kohberger means in the last sentence of his reply, quote, since this testimony will be sanitized for presentation to the jury to avoid the IGG process, it must also not falsely suggest that there was any other evidence or tip that led to the state to Mr. Kohberger, end quote. There is substantial evidence gathered both prior to the tip and subsequently leading to Mr. Kohberger being the person responsible for the November 13, 2022 homicides and burglary. The state will certainly not falsely produce or refer to this other evidence, but will rely on all of this evidence at trial to establish Kohberger's guilt. Thompson. The tip, dude, I'm telling you, because look, that was the same day, December 19th.
That's what law enforcement was.
Yeah.
And I actually saw some other channels not knowing what the tip meant.
Oh,
and
gosh.
So for your chat, the tip is the IGG.
Yes.
So it's not anything else. Now, still to be known if one of Kohberger's sisters or somebody that knew him put him as a possible suspect. I don't know.
Right. No, this is regarding specifically the backdoor genealogy process and getting to Kohberger.
And I wonder if they had other tips. I don't think they would disclose them right now, Melissa, but I am really curious.
Mm-hmm.
Like not other tips other than him, but tips on him being reported. BK toast. Oh, this is crazy. But anyways, I know you got to get going, Melissa, so I'll jump down.
Well, we're going to come back on very soon, probably not tomorrow, guys, the next day, Tuesday, and we're going to continue to go through all of these. And I'm just excited, but because we have to prepare for this April 9th hearing. It's going to be a huge hearing, pretrial hearing. And I'm really excited to see, hey, what's going to be in, what's going to be out. And I'm expecting outrage, but we're specifically going to get into lives as we finish up catching up with the emotions. Like I said, going through what is the current narratives out on the street. Where are people sitting now that so much information has come out? And we're going to debunk what we can debunk, go through what we could go through, consider with open minds all sides, but have it be based on facts. Have it be based on the evidence as we know it. And if someone has a killer theory that points within the documents, hey, well, look at this X, Y, and Z, and hey, you know what, you're right, I'm open to it. But as of right now, like I said, I'm definitely leaning more towards everything coming out just leans towards Kohberger. And until I see something different, which I'm totally open-minded with it, that's where I'm sitting.
Likewise. Yeah, I want to definitely debunk some of the DURUG house rumors are starting up again, and I hate it because the speculation it's already a hard subject to allegate towards somebody, but they're starting up and we got to put a stop to it.
Yep. So we're going to go over to Allie's. Here is her link, and we're going to start And I saw you put, thank you, Allie. It's okay. So we'll do George Anthony's I have to like kind of like take a minute and prepare for this. Because it's going to be emotional, but George Anthony is going to be the first witness up on the stand. It's the state's witness. And so we're like officially now into trial, and I'm really excited. And I honestly, Shay, I keep thinking, and I keep mentioning it to Allie, because I'm like, to see this trial and to be able to study this, especially before we go into Kohberger's, I think it's massive, because Casey specifically, you have a bunch of circumstantial evidence there, right? But it really can go any way. And to be able to observe how prosecution does this, how defense does this, and to try to see how the jury is taking it and how we take it now that like so much time has passed, I think it's very important to educate ourselves so we know what to look for as we enter Kohberger's trial.
Absolutely. No, and I'm looking forward to y'all's coverage. So I'm going to sign off so I can be ready. Oh, she's around. She's around.
Been around, guys. She's never left. She's always here. She never left. I have people who are like, Kim was right. I think because probably like the Snapchat got mentioned, but again, the Snapchat was always. We'll get into that when we get into our live. What's going on?
Right. Well, Kimberly never left, and neither did Dot, because apparently Dot like inserted herself in the Sebastian Rogers case again.
Way. Dot did too.
Yeah, Dot did too. Dot keeps dotting around, so she definitely did, or they did.
Yeah. Oh my God. Yeah, well, that's why I'm saying I'm excited once we finally get through all the motion. It's like, all right, now let's chit chat, because this is what me and Shay did. Okay. Like I said, it started with coverage, and then it was like, oh wait, there's crazy misinformation going on. We need to like, hey, debunk, because it, naturally people would bring it to the channel, like, hey, did you hear this? Did you hear that? And it's like, whoa, and it became the debunking series. That's really what it became. But now I feel like we need to kind of slow down and have a conversation about what these other creators are putting out, because I see that coming into my chat too. And if you're going to bring that into the chat, please come with sources, please come with receipts, please come with the facts, not just something, because I could come right now and say, hey guys, I have a source, and this source tells me that it was Bryan's mom who actually, I could pull a JLR on you, okay? I'm going to say it's Bryan's mom, okay, who sat in a lawn chair. And as she was sitting in this lawn chair, she observed Bryan from over the fence going through his car with gloves on, okay? I could do that right now. How the hell would you trust me enough to believe that, hey, you have this source? Doesn't mean I have a freaking source, like that's why I don't like the source shit. If you can't come and say it with your chest, then don't come and say it at all. But I have so many people who are just like, this person said it, this creator said it. Who gives a shit?
Well, and we got to see too behind the scenes, Melissa, that creators across different platforms would also quote the source thing, and then seeing the messages and hearing their explanation that source was really a troll. They were never a true legitimate source.
It goes so far down, and we have hours of receipts recorded. You guys would be mind blown to know the reality of how many creators are in it together. Okay. And nobody is around for the retraction, right? They're there for the accusation, though. When it's bombshell clickbait, hey, I got this, it's like, psh, but nobody remembers, hey, that never ended up coming to fruition. That wasn't true.
Right. And I think it's fun because like we both enjoy a good conspiracy, but like debunking something, it's not that like I want to debunk you, but like causing so much chaos, it's hurtful to others, and sometimes you just got to do it.
Yeah. Absolutely. So we're gonna be doing that, but we have a lot to catch up on before this April 9th.
Okay. I'm jumping. Love you. Goodbye.
Thank you. Love you. And sorry it was shorter, guys. But we're, like I said, we're doing back-to-back. Tomorrow is Members Only Monday, and we'll be immediately on Patreon tomorrow night after Members Only Monday. So we'll do back-to-back there too. Hi, Pickle. Kim's alt is 2-year-olds are running the world. FYI. Thank you, Pickle. Good to know. The more you know. So we're going to Kimbleweed out of here. And we are going to go over to Allie's, and we're going to be live over there in a couple of minutes. And we're going to go listen to George Anthony take the stand as the first witness in the case against Casey Anthony. So thank you all for being here. Hit that thumbs up if you already haven't. And I will see you back here after Allie's tomorrow night for Members Only Monday. And check out ATS News. She'll be going live soon, and we're going to get her back, and I'm so excited. But especially with the NK stuff, if you haven't checked out ATS News's Watts documentary, I'm telling you, it's better than like the ones that you see on Netflix. And so like it is so well done. So definitely go check her out also. And I'm just so excited to have her back. So thank you. And hi, Pickle. Good night, Long Island Hillbilly. Have a wonderful night. And we'll see you guys at Allie's.